applicants and their members, and they wish to participate in these proceedings in the capacity of interested parties. Cartoonists, East African Cartoonist Society, Cartoony,
yes,
and Bloggers Association of Kenya, BEC. Thank you, my lord, and my apologies for only being instructed.
have you filed a formal application?
My lord, we make an informal oral request considering the timeliness and the urgency and the nature of the proceedings under the Mutunga rules.
Let me deal with the business at hand. Mr. Nyamodi, the regional commander, may I have his name or her name?
The regional commander is Mr. Benson Mofi Kasioki.
Mr. Benson?
Yeah, my lord.
Sorry, Mr. Benson
Kasioki.
Kasioki. And you are the regional?
Criminal investigation officer.
Nairobi City Council. Mr. Kasioki, you can take your seat. I will not place you under oath, because my orders were specific to the 9th respondent. I'm not minded to have Mr. Kasioki under oath in that respect. Mr. Nyamodi, I'll give your client up until the hearing of Friday, just like the other respondents and interested parties, to file and serve response.
Most of it.
If the scope is not a light issue, no, Mr. Nyamodi, I'm not that formal. You can take it. I'd want us to agree on something. Under Article 25, habeas corpus is a non-derogatable act. It cannot be limited, no justifications, no excuse. And the High Court, when it is seized of something under Article 25, it plays a quasi-inquisitorial, perhaps even a quasi-investigative function. The Bill of Rights did not come by accident. The people of Kenya built it based on their experiences, their hopes and expectations. I say this to say that, just as is stated in the Mutunga Rules and in Article 159, we shall not belabor proceedings. This we will get to the substance of the matter. And the substance of the matter is whether the 2nd to 7th petition applicants are in state custody or others. So unless there is any party that is saying they will not be able to file and exchange responses so that we have a hearing on Friday, I will confirm that hearing. Is there anyone who needs more time? Mr. Nyamodi, I'm looking at you.
I know it would be out of place for me to ask for more time. I shall endeavor to comply with the time, but when the midnight oil and put the responses in.
Perhaps you can whisper with Mr. Kasioki for a few minutes, because what I would wish to see is a response that is not in the nature of the proverbial ostrich, where the NPS is saying, we did nothing, we saw nothing, we had nothing, we did nothing. I'd want the NPS to play its constitutional investigatory role and shed light on the whereabouts of these 6 individuals, their circumstances, and if they truly do not know, they would have arrived at that conclusion after a very comprehensive investigation.
That is well understood, my
Yes, so I'm giving you the opportunity to say Friday is not perhaps practical. Can we take an?
Can we then in that case, my lord, take 7 days?
Senior Counsel, just a moment. I think the rest are feeling a little bit left out.
7 days from today, my lord.
Tuesday next week. Let me hear from me begin with Mr. Thande Kuria.
Yes, Your Lordship, I come from the Supreme Court of Water, Mr. Nyamodi, and we have had the court statement in terms of the provisions of Article 25. Therefore, our view,
Yes.
the matter that definitely and also an issue that we want to go over with the issues that are being raised are very, very simple. But in terms of filing substantive, this matter was solved on the 6th of we have not had enough time to face ourselves of the matter. But nonetheless, we are here. Perhaps if you can grant us maybe sufficient time, so if you agree with all the parties, 7 days sufficient for us to prepare very well and come before you, address all the issues that have been raised in this constitutional petition, and also bearing in mind that I've just looked over my phone, I've seen the other petition that I've also been serving, the other misdemeanor criminal petition that been served from the Attorney General. Then there is also the issue of jurisdiction where the other matter is pending and which court between this court and the criminal decision that should be handled. So that we address all those issues in sufficient time, bearing in mind that the right to be heard is also a constitutional right that benefits also Article 50. The respondent grant us the 7 days to prepare the responses and come before you for a hearing when we have put our houses in order, given the limited time we have been able to appear before you, and not stating that as an advocate of this book that is a matter we are taking lightly, is a matter that is really considered the respondents that I represent. And my Lord, if you look at the nature of these orders, perhaps even for today,
Yes.
we may look also at maybe the conditions of Article 245 in terms of what the IP is supposed to do and what, particularly the second respondent, the fourth respondent, the cabinet secretary is supposed to do. They are considering the limitations of exactly what the CS is supposed to do and cannot give instructions to the inspector general. So there are issues we may need to, legal issues, serious legal issues we may need to address, including the threshold of evidence that has been placed before you, so that you can make that determination whether the applicants are in the custody of the respondent or not. I think that is one of the foundational issues of an order of habeas corpus. Then, of course, the rest of the issues involve whether this constitutional petition will morph to something else. Therefore, my plea is that you grant us 7 days as a respondent so that you can substantiate respond.
Thank you, Mr. Kuria. Mr. Kihara, Mr. Ogola.
Yes, on our part, we wish to issue our formal response. The requested 7 days would be sufficient for us. We appreciate that we were served yesterday, but we have yesterday afternoon, but we have been able to appear for today.
Yes.
The 7 days will also give us ample time to seek instructions. And I believe, come the 7th day, or rather the days that the court will be for hearing, each of the parties before you will have filed responses to enable this court to determine this matter as quickly as possible. So, in a nutshell, the 7 days are sufficient for us to respond to the petition.
Thank you.
And I wish to just further mention, I've had there's been a discussion about a petition before Justice Mutati.
Yes.
I have not had sight of the same. I do not know exactly what the issues are, but I believe if the court has already closed that application, we can get directions as to whether this matter is consolidation or not. That would be all I know.
Thank you. Anything to add, Mr. Ogola?
Looking at the prayer of the petition, and the other sort of the application, does it not make sense to subsume the application into the petition that we determine the petition as opposed to splitting. Because then when you hear and render ruling on the application, there's a very great possibility that you could as well be determining the substantive issues in the petition. We have seen that even in the other petition, where upon resolution of or termination of the application, the petition was largely overtaken in defense. So maybe you are seeking direction if it makes procedural sense to subsume the application into the petition and then to take direction on disposal of the exchange of responses to the petition. And then we determine the position.
Thank you, Mr. Ogola. Before I hear from Mr. Witty and Mr. Jurge, Mr. Nyamudi, does that work? We subsume the application into the petition and we hear the final vendor.
Yes, that would work. And I wish to add further that I am of the view that that's going to be the best use of judicial time, because the matter is concluded when the petition proper is determined.
Mr. Owiti, Mr. Jurge?
Yes, my lord. Let me start by saying that we appreciate the seriousness of this matter.
Yes.
And that we are taking it as serious as it is. On our part, we wouldn't mind proceeding either way, dealing with the notice of motion first before the petition. I think it would be better if we proceeded straight to the petition.
Yes.
On behalf of the Director of Public Prosecutions, while we acknowledge the orders of the court, we were ready to file our responses within the time provided, but to effectively and efficiently respond, we join the views of our colleagues that 7 days would be sufficient to enable us respond to the petition directly, if that is the direction.
Thank you. Mr. Manat?
My lord, on behalf of the first interested party,
Yes.
we were willing and ready to put in our response within the 2-day period. Within the orders issued by the court, I will propose the application for 7 days, which I believe will be sufficient to respond to the issues that have been raised.
Thank you. Mr. Kamal?